Honorable Court of Appeals of Tennessee is now in session.
Good morning, gentlemen. We're delighted that you have chosen to join us in these proceedings this morning. We will conduct these proceedings as if we were actually in court. But if anything comes up during the process of the proceeding, please let us know immediately so that matter can be corrected and taken care of. Okay. If there is no preliminary matters, then Mr. Clerk, will you call the first case, please?
Vernon Mott versus A. Jeffrey Luethke, Esquire, et al.
Mr. East.
Good morning. I'm Todd East from the Kingsport Bar. I may ask if I may reserve 5 minutes on rebuttal time.
You may.
I represent Vernon Mott in a car wreck that happened on March 22nd of 2016, and I want to give you a few of the facts in the background on it. Suit was filed on March 3rd of 2017, and the defendant had died prior to suit being filed. After suit was filed, a couple of months, we found out that the defendant was deceased when we tried to serve the papers. And so therefore the survival statute comes into play, which basically the purpose of the survival statute was to, allow you to sue a dead person, for lack of a better term, and it abrogated some of the prior common law. And one of the issues here today is, well, is there strict construction of the survival statute? And well, yes, there is, but strict construction doesn't mean you forget the rest of the rules. And from our position, for instance, some of the cases the defense is presented says you don't consider Rule 1503, and you don't consider anything else equitable arguments at all. And we don't think just because it's an aberration of the common law rules that you throw all the rest of the rules out. Now, that was addressed and looked at in the Dole case, which was a Governmental Tort Liability Act, and basically that being an abrogation of the common law rules, you use strict construction, but the courts also in Doyle allowed for the use of all the rules. And so we think that you can use all the rules even under the survival statute. Now, this particular case, once suit was filed and found out that the defendant was deceased, on or about August 23rd, I filed a petition for an administrator ad litem. And if you use the 6 month from the survival statute date, everything's timely up till September 20th. We had filed it, and in the petition, Mr. Luethke, a lawyer in the Kingsport Bar, signed the order on August 23rd to accept the appointment. However, the clerk and master did not sign it till in October, which would be after the running of the statute. The August 23rd date is important from our standpoint because it is timely. The defense has notice of everything, and they know a suit's going forward, which is not really disputed because that had been a matter with the defense ever since shortly after the case happened. We were trying to get the matter resolved. Well, after we had filed for the administrator ad litem, we received a letter which brings in kind of the second part of our argument. Our first argument is that just because it's strict construction, you shouldn't throw out the rest of the rules. Our second argument was an equitable estoppel argument, is that we got a letter on about September 7th saying, hey, let's try and get this thing settled. And I think by the basis of the letter, they didn't realize that we had already filed a asking for a petitioner administrator ad litem, but we had. But in any event, when we got the letter, the attention kind of focused to say, hey, let's try and settle the case. And so that's what we did. We tried to gather the records and everything else. And when it became apparent that we were not going to be able to settle the case, then we got back in order to try and get the pleadings in order to go forward. And in this particular case, we're asking that as in the Grantham case, the Supreme Court basically said, well, if you're going to relate back, there's a couple of things you got to look at. One is, did the other side have notice, and is there any prejudice? And basically, but for that fact, would that there would be a suit? And that's very similar to ours. Is that in this case, there was notice is not an issue, prejudice is not an issue, which are the two primary issues that you look at in suits, and kind of like a mislabeling issue, as the Grantham court put it in there, that that's the best way to describe it, and they allow it. Well, ours is different than most any of the cases that had been cited, because our case dealt where the petition for the administrator was timely and everything would have been resolved, but we kind of, both sides put it on hold to try and see if we could settle it. After it became apparent that we couldn't settle it, both parties were in agreement to remove the case to circuit court, in which we did. And then we got into some discovery going forward with the case. And then the Putnam case came out, or was read or seen by the opposing side, and motion for summary judgment was filed, and that's what brings us here. So we think that there were sufficient facts for one to enable the judge to find there were genuine issues of material fact on the summary judgment under relation back under 1503, and also that there were enough facts under the equitable estoppel to not allow the statute of limitations an issue, and therefore the matter should be placed back on the docket from our position for further hearing.
Excuse me for interrupting, counsel. A question with reference to the equitable estoppel position. What representations is your client relying upon with reference to the equitable estoppel argument?
There was a letter which we received from opposing counsel on September 7th saying, hey, you've not got service on probate estate. Let's see if we can't get this case settled before we do any further litigation. And he basically, the letter said, get us the medical bills and the records, and we'll see if we can settle it so we don't have to go into any further litigation. At that point, we pulled off what we were doing in order to get the administrator and then substitution in order to try and get the case settled. And so that would have been our equitable estoppel.
This letter was issued and received prior to the time that your client had the summons reissued against the personal representative?
The petition for the appointment of administrator was issued about 2 weeks before we got the letter from the opposing counsel. So yes. And
the letter, of course, then was received prior to the time when the civil summons was reissued against the administrator ad litem. Is that correct?
That's correct.
All right.
And then when it became apparent that he wasn't going to be finished treating, it became apparent we weren't going to be able to settle it at that point and needed to get the rest of the paperwork in order. And so under those particular issues, we're asking that the estoppel come into play, and or it relates back to the original filing, which is different than most all the cases.
Question I had is, was there any period of time between the actual petition for the appointment of the administrative ad litem and the actual appointment? If so, what period of time, how much period of time was between the two?
The clerk's office received it on or about August 30th. And that's when the petition was marked filed. The order signed by the clerk and master, for some reason, was not signed until October 31st of 17. And I'd like to say, we said, just let's put it on hold. We'll see if we can settle it. But I don't know why the delay between our filing it and it was signed occurred.
Okay. Thank you. You have your rebuttal.
Thank you.
Ms. Griffin.
Your Honor, thank you. May it please the court. My name is Brad Griffith. I'm with the Washington County Bar. I represent the defendant in this case. I won't go over the facts in detail. They're in the briefs. There are also, Mr. East has already talked about those as well. All I will say is that none of the facts in this case are in dispute. And it's undisputed that the plaintiff did not file against the personal representative of the estate of Julie Grockey, the deceased tortfeasor, within the 1-year statute of limitations or within the additional 6 months provided by our statutes. There's no question he didn't do that. You didn't hear Mr. East argue that he did that because he didn't do it and he knows that he didn't do it. Instead, what we've got is an argument here that reasons or excuses why he didn't do it, and asking this court to not hold him to the strict construction of the laws and the rules that we talked about. Now, I'm not going to go through all the particular laws. I think everyone's probably familiar with how when someone dies before suit's filed, what you have to do. Basically, the plaintiff has to have a personal representative of the estate appointed and has to have that personal representative substituted as the defendant. So the plaintiff was speaking today, Mr. East, about this August 23rd, 2017 petition. That's a petition, not being actually appointed. While that is within the statute of limitations, the actual appointment didn't happen until October 31st, 2017, which is outside the statute of limitations. And the actual first reissuance of the civil warrant with the administrator as the defendant did not occur until January 31st, 2018, months after the statute of limitations ran on September 20, 2017. So he did not do either of those within that time period. I would point out two cases, one that Mr. East just brought up briefly, Putnam versus Leach. It was, I think, by the Western District Court of Appeals in 2018. And in every aspect that is material to this case, Putnam and our cases are the same. In both cases, the defendant died before suit was filed. In both cases, the plaintiff sued someone who was already deceased. In both cases, the family of the deceased person did not open an estate. In both cases, the plaintiff did force the opening of an estate for purposes of litigation, but it came, in both cases, the actual appointment came after the statute of limitations. And in both cases, the plaintiff did also eventually have an amended civil warrant or amend their complaint to add the personal representative of the estate. But in both cases, that came long after the statute of limitations had run. In this case, months afterwards. The statute ran September 20, 2017, and the reissuance of the civil warrant with the administrator as the defendant was not until January 31st, 2018. So the Court of Appeals in that case dismissed the case, upheld the dismissal, which is what we're asking the court to do in this case.
What year is that case?
It's 2018.
Okay, I think I was on that case.
You may have been. Putnam versus Leach, 572 Southwest 3rd, 605.
Yep, I think so.
Thank you. The other case that I wanted to talk about was Vaughn versus Morton. And Vaughn versus Morton was decided by this court, the Eastern District Court of Appeals, in 2012. And in that case, the plaintiff had an even stronger case than the plaintiff does in this one. In that case, the actual appointment of the administrator had occurred before the expiration of the statute of limitations plus the 6 months. But what the plaintiff didn't do in that case is the plaintiff did not substitute the defendant, the personal representative for the defendant within the 1 year statute plus the 6 months. So that plaintiff had an even stronger case. But this court again upheld the dismissal of that case. They held, and this is a quote from the court, the plaintiff's failure to strictly follow that last mandatory step of securing the name of the personal representative as the defendant before the expiration of the statute of limitations is fatal to his action under our holding in Bryant. It's fatal to his action. It should be fatal to the plaintiff's action in this case as well, because he did the same thing. There was no amendment to bring in the personal representative until long after the statute of limitations plus the additional 6 months had run. Particularly with regard to Mr. East's two arguments, I'll start first with the relation back, the 15.03. He had said earlier that that maybe some of the cases that I've cited and relied upon says you don't consider 15.03. Well, that's not true. They consider 15.03. They also consider Rule 3, and both of those also go against the plaintiff as well. The problem with this type of an argument, I think, from the plaintiff's perspective, is that when he filed the original civil warrant in General Sessions Court against Ms. Grocky, who was deceased, that this is not a proper filing. And this is what this court heard in the Vaughn versus Morton case. They determined that if you file against a deceased person, that does not commence a lawsuit within the meaning of Rule 3. They then said that if there's no lawsuit commenced within the meaning of Rule 3, there can be no relation back under Rule 15.03. So the courts are not ignoring the Tennessee Rules of Civil Procedure. In fact, they are applying them as they are written. No strict construction, just as they are written to this case. In Vaughn versus Morton, the court said, does the filing of the motion to amend relate back to the filing of the original complaint that named only the deceased? The answer is no. This court said that the statutory language is abundantly clear. In another quote, they say, since the statute defines the exclusive remedy and the steps to be taken to secure it, those steps must be strictly followed. And in this case, the plaintiff had to strictly follow these rules as well, and he didn't. And Mr. East is not, I don't think he's trying to tell you that he did, because he didn't. The court goes on to say that if a complaint does not commence an action within the meaning of Rule 3, it does not commence an action that a later amendment can relate back to within the meaning of Rule 15.03. So they're not ignoring. The court did not ignore Rule 15.03 or Rule 3. They actually applied them, and they don't come out in Mr. East's favor as well in this case. In his brief, Mr. East relies on the case of Vincent versus CNA Insurance Company, but reliance on that case is also, it's misplaced. First of all, it did not involve the Tennessee survival statute that we know from our court that says has to be strictly construed, and it's the only way that you can sue someone who's already passed away, because our survival statute actually abrogated the common law, so it makes strict construction. So this case did not involve that. What it involved instead, somebody had sued the insurance company instead of the driver of the vehicle. And so it was a simple substitution of parties. It did not involve a case that was not properly commenced under Rule 3, such as the one we're talking about today, which is also the one that was in Vaughn versus Morton.
What do you say about the petition for appointment was in August and the actual appointment was not until October?
Well, the first thing I would say about that petition is that I was not provided a copy of it. There's a certificate of service on it that sends it to Mr. Luethke, who's an attorney who shares office space with Mr. East. Maybe he received it. I did not receive it, did not know about it when this was going on. But secondly, just because you file a petition, that's not what the cases and the statutes say you have to do. To properly do it in this case, you have to file a petition. There has to be an appointment of this petition, and there has to be substitution of the personal representative for the deceased person, all within the statute of limitations. In this case,
the fact that the petition was filed, does that take it out of his hands, though?
I don't believe it does, Your Honor. The Vaughn versus Morton case was relying on a case called Bryant versus Klein and speaking about it. And a similar situation happened there. In that case, in the Bryant versus Klein case, what was going on was the actual plaintiff's was sending copies of everything to the attorney for the estate, but he didn't actually sue the attorney for the estate. The Bryant case held that that's not good enough. Sending somebody copies of these pleadings is not good enough. Notice does not matter when the proper defendant was not filed against that estate. So I don't believe that that it should be even considered. The petition does not matter because the other steps were not met. These steps have to be met in strict compliance, and they weren't done by the plaintiff in this case.
Okay.
As far as the equitable estoppel argument is concerned, first of all, I don't think that this court should even entertain the letter that I sent to plaintiff counsel. This was dismissed on a motion for summary judgment. In a motion for summary judgment, the trial court and this court should only look at things that were actually included in the statement of undisputed facts with citations to the record. That letter was not included in any statement of undisputed facts by me or by Mr. East. The trial court looked at it and still dismissed the claim of equitable estoppel. Also, there's no evidence before this court that the plaintiff actually relied on that letter, actual reliance. Now, there's arguments made by Mr. East, but there's no actual evidence that's admissible that would say that they relied on it. This evidence certainly wasn't in front of the trial court when they heard the motion for summary judgment. It could have been the plaintiff or his attorney could have drafted an affidavit and signed it, said we relied on this, that's why we didn't file. But they didn't. There's no evidence that there was actual reliance on any statements there. But if you move forward.
Interrupting counsel, the trial court did not consider the letter in connection with the Rule 56 motion?
She did. When I brought it up, the response basically was, well, let's say that I'm going to consider it. Then tell me your arguments. That's how she did that.
Copy of the letter is in the record, I presume.
It is in the appellate record, yes. Basically what the trial court did on that was that she said that the statements made in that letter is not enough to equate to equitable estoppel. A question, if the plaintiff was really if he was going to rely on these statements to say that, oh, well, we don't have to do this, we don't have to substitute the personal representative, the next question that automatically comes to mind is, if you're relying on that, why did they move forward with having the appointment in October? Then why did they move forward with filing the amended civil warrant later in January? If they were relying on that and thinking we were trying to get this matter settled, the answer is because they weren't relying on it, because there was no statements in there no promises, no agreements, no inducements, nothing. There's no statements that we're waiving defenses. There's nothing to even imply that we would be waiving defenses. The plaintiff relies on the Hardcastle case, and the Hardcastle court said several things that I think are important to keep in mind about equitable estoppel. One, that courts shouldn't be quick to invoke equitable estoppel. Two, the statutes of limitations are favored. Three, that estoppels are not favored. Four, the court has to consider if the defendant's conduct sufficiently unfair or misleading to outweigh the public policy favoring statute of limitations. And then five, that the plaintiff has the burden of proof to prove equitable estoppel. And as I spoke earlier, he's got no proof to prove that there was any equitable estoppel, that any reliance on it. But if you look at the letter itself, as Mr. East said, and I wrote down what he said in his argument, he said the letter said, let's try to get this thing settled. And that's basically what the letter says. I think the specific thing he's discussing is that it says, you and I had discussed the possibility of getting this case resolved without opening an estate solely for the purpose of litigation. But it says the possibility. There's no promise in that statement. There's no agreement. There's no inducement. We discussed this possibility. The rest of the letter is as Mr. East said, send me your medical records, your medical bills, tell me how much you want, we can settle it. Letter that's sent probably hundreds of times a day by defense counsel across the state. There's no inducement. There's no promise. There's no agreement. There's nothing in that letter at all. Now, briefly, the plaintiff talks about strict construction in his brief. And as I said before, nobody's ignoring the rules of civil procedure. The courts actually are applying the rules of civil procedure, and they just don't come out the way the plaintiff would like them. And the cases in particular that Mr. East is pointing out involve GTLA, workers' compensation. These cases do not involve they do not involve the survival statute. They do not involve cases where there was no proper commencement of the cause of action. In our case, there's no proper commencement of the original cause of action on March 3rd, 2017, when the original civil warrant was filed against the deceased person. The court in Vaughn versus Morton and Bryant versus Klein both said that's not a proper filing under Rule 3. With no proper filing, you can't apply Rule 15.03 because there's nothing to relate it back to. So while the plaintiff is claiming that strict construction is not proper for these, there's no strict construction in those. They're not ignoring them. They're actually applying them. And the applications do not point in the plaintiff's favor. Basically, the whole case boils down to the fact that the plaintiff did not file within the statute of limitations. He didn't do what he was supposed to, did not follow the law, and he's now asking that this court excuse the fact that he did not follow the law. Thank you.
Yes, sir. Yes, sir. Your rebuttal.
Yes, sir. A few issues, please. We submit under the estoppel issue, there are issues of fact disputed. And if you take things most favorable as in light, most favorable to the plaintiff, those issues are disputed, and the court was improper in granting the motion for summary judgment. Second, there was a reference to the abrogation cases, and the reason that we've got those, it shows that strict construction does not eliminate the rules of civil procedure, does not eliminate the equitable arguments, that it's not in a vacuum. It's and it all kind of leads back to the issue as to, you know, the Grantham court, you know, when you determine when you've got basically a name change, when can you relate it back? And you almost want to put the argument, is it form over substance, substance over form? But the bottom line, what these courts have looked at is, one, is there notice to the defendant? And yes, there's notice to the defendant. They've known it all along. Is there prejudice to the defendant? No, there is absolutely zero prejudice to the defendant. And then those are the two primary issues that they look at if they're going to allow it to relate back. So that would be the argument of 1503. The issue under the reliance and most favorable under the equitable estoppel. Once again, I think there are genuine issues that the court should have considered and did not consider. And we'd ask the court here to send it back consistent with that issue. That's all.
One question I had, when you received this letter regarding let's negotiate, had suit already been filed?
Yes, sir. Suit was originally filed in March. When we got notice the defendant had died, when we tried to serve the papers in May, we still tried to get the matter settled. We filed in August for the petition for administrator ad litem. The letter came after we had filed our petition requesting an administrator ad litem.
After you filed the petition, but prior to the appointment?
Yes.
Okay.
And prior to the running of the statute.
Okay. Thank you very much. Anything further?
No, sir.
Thank you very much. Gentlemen, thank you very much for your presentation. We will review this record and issue an opinion in the due course of time. Thank you.
Thank
Thank
you.
you.
This honorable court is now in recess until 11 a.m.